Recklessness. Recklessness is the taking of an unjustified risk. Recklessness in criminal law, however, has given rise to more difficulty. It became a difficult question as to whether a subjective test should apply to recklessness or whether an objective test should apply. So, two different tests have been developed by the courts. As a result, recklessness began to have two different legal meanings which applied to many offenses. For a long time in English criminal law, subjective test applied to non-fatal offenses against the person and objective test applied to criminal damage. I'm going to discuss the journey of development of these tests and will eventually talk about the current situation where we are now back to having just one test, which is the subjective test. Let's look at the Cunningham or subjective recklessness and see how did the test develop. This test for recklessness was developed first in R.V. Cunningham, 1957. The appellant ripped a gas meter from the wall in order to steal the money in the meter. This caused gas to escape. The gas seeped through the small cracks in the wall to the neighboring property where his future mother-in-law was sleeping and was poisoned by the gas. He was charged under Section 23 of the Offenses Against the Person Act 1861, which provides, "Whosoever shall unlawfully and maliciously administer or to cause to be administered to or taken by any person any poison or other destructive or noxious thing, so as thereby to endanger the life of such person, or so as thereby to inflict upon such person any grievous bodily harm, shall be guilty of felony." The trial judge directed the jury that malicious meant wicked. The jury convicted the defendant and he appealed. Court of Appeals held that malicious means either 1. An actual intention to do the particular kind of harm that in fact was done, or 2. Recklessness as to whether such harm should occur or not, that is, the accused has foreseen that the particular kind of harm might be done and yet has gone on to take the risk of it. This meant that the defendant knows the risk, is willing to take it, and takes it deliberately. The question that must be asked is, was the risk in the defendant's mind at the time the crime was committed? Cunningham recklessness was followed in R.V. Briggs. However, in latter case of R.V. Parker, 1976, modified the test to include closing one's eyes to an obvious risk. Okay, then these cases were reviewed by the Court of Appeal in R.V. Stephenson. It was held a subjective test applied. Then came MPC versus Caldwell, 1982, and the second test for recklessness was developed. This test was objective. This means that the risk must be obvious to the reasonable man, in that any reasonable man would have realized it if he had thought about it. Remember that this was the case of criminal damage. Let's look at the facts and the decisions to shed some light on it. This appellant had been working at the hotel and had a grudge against his employer. One night after consuming a large quantity of alcohol, he went to the hotel and started a fire. The hotel had 10 guests sleeping in the hotel at the time. Fortunately, the fire was discovered and extinguished early and no people were actually harmed. The appellant was convicted of aggravated criminal damage under Section 1(2) Criminal Damage Act 1971 and appealed in relation to the required level of recklessness. The defendant argued that he had given no thought as to the possible endangerment of life due to his intoxicated state. House of Lords upheld his conviction and formulated what has become known as Caldwell recklessness, which is, a person is reckless as to whether property is destroyed or damaged where 1. He does an act which in fact creates an obvious risk that property will be destroyed or damaged, and 2. When he does the act, he either has not given any thought to the possibility of there being any such risk, or has recognized that there was some risk involved and has nonetheless gone on to do it. Under this test, a person was reckless in the new wider sense when he performs an act which creates an obvious risk, and when performing the act, he has either given no thought to the possibility of such a risk arising, or he recognized that some risk existed, but went on to take it. In latter case, it was affirmed that the risk must be obvious to the reasonably prudent person. It need not be obvious to the defendant. Very soon, the Caldwell loophole was discovered. This took into account that there may be a case where a defendant considered whether there was a risk of harm and decided that there was none. Such a person is not reckless within the precise wording of Lord Diplock's definition in Caldwell because he has given considerable thought to the risk, but came to the wrong conclusion as to its significance. This situation referred to as the lacuna or loophole in the Caldwell principle. Caldwell recklessness was criticized widely. It was said that it is unjust to have two meanings of recklessness. The Caldwell test does not make a distinction between the person who knowingly takes a risk and the person who gives no thought to whether there is a risk or not. In addition to causing injustice, other criticisms of Caldwell recklessness, such as, while criminal damage was subject to Caldwell recklessness, Cunningham recklessness applied to offenses against a person, and thus property was given a greater level of protection. Another criticism included that the precise limits as to which offenses required which type of recklessness were not fully understood or defined. Having two definitions for the same word was confusing. Plus, the test was difficult for juries to understand. Having an objective test blurred the distinction between negligence and recklessness. Then there was this uncertainty as to whether the Caldwell lacuna existed. And finally, Caldwell recklessness was overruled in 2003 by the House of Lords in RVG&R 2003. In RVG&R 2003, two appellants aged 11 and 12 went camping for the night without their parents' permission. The boys found some old newspapers outside the co-op, which they lit with a lighter and then threw them under a wheelie bin. They then left without putting them out, assuming they would naturally burn out. In fact, the burning newspapers set light to the wheelie bin and the fire spread to the co-op shop and caused over 1 million pounds of damage. The defendants' convictions were quashed. The House of Lords overruled MPC versus Caldwell 1982 and held that the appropriate test of recklessness for criminal damage is a person acts recklessly within the meaning of Section 1 of the Criminal Damage Act 1971 with respect to 1. A circumstance when he is aware of the risk that it exists or will exist. 2. A result when he is aware of a risk that it will occur and it is in the circumstances known to him unreasonable to take the risk. So, subjective standards now applies to the criminal damage and the objective Caldwell recklessness is out of the window.